Greetings of the day. In the today's session, we are going to discuss about the Industrial Dispute Act 1947. The objective of the session is to understand what is this Industrial Dispute Act, what are the objectives of this act, and how this objective and this act dealt with the different situations, what are included in it, what are not included in it. The outcome of this session will help you to have the crystal clear clarity of the thin line of the various rules of this act. Industrial Dispute Act 1947 settled under the provisions of the Dispute Act 1929. Working of 1929 Act revealed the few shortcomings, so because of that, few amendments were taken place. While considering those shortcomings, and the new act introduced, or I can say the amended act introduced in the name of Industrial Dispute Act 1947, which indicates the proper machinery to settle disputes in the existence, the form of work committee, conciliation officer, board of conciliation, court of inquiry, industrial and national tribunal. The act with the various scopes. The scope of this act, that Industrial Dispute Act 1947, is to promote the measures for securing, preserving amity and good relationship between the employer and the employee. The objective basically is to reduce the differences and to settle the disputes among the employer and the employee. Let them be both on the same platform to contribute their best efforts towards the organization. Avoid, or you can say prevent, the illegal strikes, lockouts, give them the proper relief in the matter of layoff, retrenchment, or any other wrongful dismissal of your employees. It ensures to give the workmen the right of the collective bargain and promote the conciliation. Whereas the scope of the act is basically to achieve the harmony, balance in the employer and the employee, promote the economic and social justice, clarify, justify the act as a welfare legislation, and this act called as the Industrial Dispute Act 1947 extends to whole of the India. So this is your Industrial Dispute Act. Now if anyone talks with you that who is workman, what is industry, what is not included in the industry. So let us discuss something on this platform about all these aspects. Before that, it is very important to understand the industrial dispute. The industrial dispute and what is industry. Industrial dispute, for that the various associations or the corporations are there. Any industrial dispute which is concerned to Employees State Insurance Corporation, Industrial Finance Corporation of India, Indian Airlines, right? So they are under their different sections as well as in their different acts. Industry is somehow any which carried out certain tasks, certain issues, and governed or authorized under the central government, state government, or any owned by any government. So those are in the part of industry as per this section of the act. right? So if anyone asks you that what is employer, so employer under the section 2G, that is in relation to who carried out by or who carried on by or under the authority of any department of central government, state government, who carried on and by behalf of local authority, that is said as employer, right? Now if you talk about that what is the industry and what is treated as workman. So workman is the one who is a person employed in any industrial establishment to do skilled, unskilled work, technical work, clerical work. So that person who performs, who dismissed, who discharged the duties is said as workman. Industry. Industry is the one where the systematic activity carried on by the corporation between employer, employee, right, for production, supply, distribution of goods, services to satisfy the wants, to satisfy the needs, right? So that is the part of the industry. Now what is, if anyone says what is actually not included in industry, so not included in industry is hospital, dispensary, agriculture, education, any industry or institution owned, managed, wholly or substantially engaged in any charity, social service, khadi industry, any industry with the supervision functions, though are not included in it. Any domestic service, any activity, any profession which is practiced by the individual or the body of the individual. If I talk with you now, as we started with the topic industrial dispute, so what is actually industrial dispute? Industrial dispute, the dispute within the, as per the section 2K of 1947, the dispute means the differences within the individuals, the differences in the opinion of the individual. So here the differences between employer-employee, employer-workman, with the employment of the non-employment, right, with the terms of employment, with the either with the conditions of the labor. So either on any of the aspect, the differences in the opinion in the both parties is there, that becomes industrial dispute. So this is the base of this whole section, where the Supreme Court also says or defined in the legal language, the industrial dispute is observed as a dispute of differences or differences between employer-employee, or a dispute of differences connected with employment, non-employment, right, or in the terms and the conditions of labor or any person, right? So this is said as industrial dispute. Okay, so if I ask you, or if anyone says you that is it possible to dismiss the individual or the workman to be deemed to be an industrial dispute, so section where this section 2K says about the industrial dispute, section 2A also says that where employer discharges, dismiss, retrench, right, terminate services of employee workmen, disputes differences between the workmen and the employer connected for discharge or dismissal or retrenchment, deemed to be industrial dispute. So no other workman nor the union of the workmen is the party to the dispute. Above all, section 10 says that the workman, as is specified in subsection directed to Labour Court Tribunal for the adjudication of the dispute, referred to where after the expiry of 3 months from the date he has made the application to the conciliation officer of appropriate government for the conciliation of dispute, the receipt of that application, the labor court or the tribunal shall be the power and the jurisdiction to adjudicate upon the dispute. Above all, that application refers to subsection 2 made to the labor court or labor tribunal before expiry of 3 years from the date of discharge or dismissal or retrenchment, termination of the services. Right? So, in this session, I had discussed lot of sections with you. In the next session, I am going to discuss with you, after all, what is the settlement machinery and the authority in the Industrial Dispute Act 1947, how the Work Committee, Board of Conciliation, Labor Court, Labor Industrial Tribunal, Court Inquiry actually works, which is very important to understand for all of us. Thank you for patiently listening me, and thank you for your support. Please subscribe and like my session and ensure me and let me know any new topic you are looking for to understand. Thank you.